And the end of our course, the last couple of lessons, is a foray into a new area of employment rules. Obviously, employment rules are very heavily related to business law, and even though it's not really necessarily about business organizations, as we've been discussing until now, because of the fact that people who are in business and people who are practicing business law have to deal with employment law a lot, we figured we'd append it to the end of this course and make it a component of this course. And we're going to discuss employment law in two basic chapters, two basic lessons. The first one will briefly go over some of the basics of employment, and then we'll discuss some of the concepts of employee benefits, of what employees get in exchange for their work, and then we are going to discuss employment discrimination a little bit later on. First of all, we've got the concept of an at-will employee. In many states, an employee, unless stated otherwise, unless the employee has a contract, is inherently considered an at-will employee, which means the person is only there as long as the company wants the person hired. An employer in an at-will state, or if there's no contract that says otherwise, can fire an employee at any moment, really for any reason. So this is an at-will employee, somebody who does not have an employment contract, and that person can generally be fired. However, there are some times or some reasons that you are not allowed to fire somebody. And we'll discuss that more when we discuss discrimination, but there are discriminatory reasons you're not allowed to fire somebody. There are reasons, for example, you can't fire someone because they went and joined a labor union. You can't fire someone because they're a whistleblower. There are many rules that we'll briefly cover a little bit later on in the next lesson that are relevant to why an employee cannot be fired. However, the default rule, and the thing that's important to realize, is that a person can be fired at any time for pretty much any reason as long as that reason is not contrary to law. You don't necessarily have to have established that somebody did a bad job, although it always helps if the person sues you for discrimination, and having evidence the person did a bad job is certainly something that may help with that. There are some exceptions. There are statutory exceptions. In other words, there are laws that say that you can't be fired for reason XYZ. There are contract exceptions. In other words, you might have made an agreement with the company to be there for a certain number of years or to be there for a certain number of months, or that you wouldn't be fired without cause. There could be tort exceptions where the employer is doing something to damage you. And there could be public policy exceptions where a court can say, we think that for the good of the public policy, we really ought to prevent people from being fired based on this particular reason. Okay, let's switch gears a little bit over here, and now I want to discuss some things regarding employee benefits. And the first employee benefit I want to discuss is workers' compensation. Workers' compensation acts were based on the idea back in the old days, back in the late 1800s, early 1900s. If somebody got injured on the job, they were in the factory and they worked 12 hours a day, and they took home enough for their family to survive. And then one day they got injured by a machine at work, and then they couldn't work, and then they were home and their family starved. Well, when they started to make labor laws, they realized that that wasn't a very good system. So states have established workers' compensation routines. Now, workers' compensation is a state issue, so it does vary from state to state. The state you're in may be very different from somebody else's state in terms of its workers' compensation plan, but all states have at least some element that to protect people who get hurt on the job. So, and these people the people who get hurt on the job are paid according to preset limits established by the state statute or by regulation of a state administrative agency. The way workers' compensation works, fundamentally, is that states require employers to pay for workers' compensation insurance. Now, that may vary. Obviously, if you're a skydiver, you're probably going to have to pay more for premiums and workers' compensation insurance than if you're a desk clerk, because skydiving is a little bit more dangerous than sitting there at a desk and answering telephone calls. But employers are required to purchase workers' compensation from an appropriate agency that that will pay out if the employee gets injured. So then the employee, if the employee gets hurt, then the employee will be able to collect workers' compensation insurance money. So to recover the workers' compensation insurance, the worker's injuries have to have been employment related, And stress, and just because it doesn't mean that a brick has to fall on your head. Something like stress, carpal tunnel syndrome, even migraine headaches, or things like that that are caused based on the fact that people are sitting there at keyboards and staring at their screen for 9 hours a day, could be considered valid reasons for workers' compensation insurance to kick in. Once that happens, then of course the insurance company has to pay premiums to the worker for when the worker can't work. Workers' compensation, however, is an exclusive remedy, which means if the worker gets injured, migraine headache, carpal tunnel syndrome, a brick fell on the worker's head, whatever it is, they can't sue their employer separately. Because if they could sue their employer separately, essentially they would be double dipping. There are workers' compensation rules that say if you get injured, you get this amount of salary for the amount of time that you can't work because you're hurt, because you're on the shelf, you get paid still, but you can't sue separately, except where the employer intentionally injures the employee. When you're talking about an intentional tort, well, workers' compensation insurance doesn't cover that. Workers' compensation insurance is meant to be innocent injuries, even negligent injuries, perhaps, but it's not really a matter of fault, by the way. It doesn't if it's the employer's fault or the employee's fault, it doesn't really matter that much in most cases when you're talking about workers' compensation insurance. It's like automobile insurance. Now the premiums might go up if it's your fault, whatever it is, but it's like automobile insurance where you get paid by your insurance company if you get into an accident, even if it was your fault, because that's the whole purpose of it. It's statutorily mandated, and it's designed to protect everybody, whether it's their fault or not. So now let's look at some of the other employee benefits. And these are usually passed by federal law, sometimes by state law, but there are a whole bunch of them. Again, at the turn of the 20th century, in the early 1900s, people were working for very little, and children were working for very little, and people had virtually no benefits, no protection if they got hurt, no negotiating leverage with employees. It was pretty much laissez-faire, and if people were happy to have a job, and there was really no power that they had, and no law that protected them. So employment laws have been, are passed constantly almost, and many of these help improve the lot of the workers. One example was OSHA. OSHA is the Occupational Safety and Health Act, and this was enacted to promote safety in the workplace, and it established the Occupational Safety and Health Administration, another federal administrative agency called OSHA, and it requires certain workplace safety standards. It applies to private employers. Government employers are exempt, although they may have their own rules based on the state's rules. But what OSHA does is it imposes record-keeping and reporting requirements regarding safety and safety conditions. Employers are required to post notices informing employees of their rights. If you work and if you go to your work, you might if you look around carefully, like in the break room or whatever it is, you'll probably see all sorts of notifications posted regarding your rights. These are required by OSHA, and they're empowered to administer the act and to pass regulations, just like we saw before when you're talking about the Securities and Exchanges Commission, where they were allowed to pass regulations to enforce the securities rules. Well, OSHA is allowed to pass and enforce regulations to protect workplace safety. And these require safety standards on the part of employers. So there's a specific duty standard, which addresses a safety problem of a specific duty nature. So in other words, that there are particular industries that face certain hardships or face certain dangers, and they can make regulations saying a company that works with jackhammers has to give everybody goggles and has to train everybody for 7 hours before they actually go ahead and do it, whatever the case may be. And then there are general duty standards, which say that the employer has to provide a work environment that's free from recognized hazards that are causing or are likely to cause death or serious physical harm. And of course, it's a lot more complex than that, but those are just some of the basics of OSHA.